Okay, we are live.
Hi everyone.
Hello.
Today we're going to go over public charge, the new form, adjustment of status, the new reasons for denial, what to do, how to do it. We're going to go over all of that. Unexpected issues with this is the increase in inadmissibility and waiver requirements. A lot of fraud and misrepresentation, a lot of waiver requirements, but that directly contradicts public charge. So we're going to talk about that. That's pretty important. We're going to share two success stories, one from Amy, one from Gabby, both family-based cases. One is directly dealing with for Amy's case, it'll be directly dealing with the birthright citizenship issue as well as the adjustment of status in the United States coming in as a tourist. So two separate issues, but that case got resolved. I'm going to directly read everything. And then Gabby will be talking about a recent case that happened just this week. Marriage-based interview, DACA related, very difficult interview, a lot of challenge, but ultimately it was successful. So a lot of things that we want to share with everyone. If you guys have any questions, feel free to reach out. Let us know. This is live, right? And so let us know your questions. We'll try our best to answer as best as we can. Next week, we're skipping the live for next week. I'll be on vacation. And I'll see if we're going to do it 2 weeks from now. Probably we will. Okay, so let's get started.
Okay.
The first thing I want to talk about is the new September 45 form. If anybody who wants to file for a green card in the United States, you need to file the 45 application. USCIS is coming with a new form. And the biggest difference is that they are going to include a lot more questions regarding public charge. And for people who don't know what that is basically to assess if in the future you will likely be a debt to a social society and therefore the United States government will deny your green card. So never mind you are married to a U.S. citizen, never mind you have a great job, never mind anything else. If there is a chance of you being a public charge, the Trump administration, USCIS, wants to deny your case. In the first administration, they tried to do it, got struck down. There was multiple memos that was updated, and now the newest form, newest update is going to be in place. And this will likely change immigration for the next 10 plus years. I don't foresee the next administration, whichever party, come back and rolling this back. This has officially been approved through the system. It wasn't just an executive order, and the forms have changed, and there's going to be a lot more policy that's going to be adjudicating it. But it doesn't mean everything is clear, because how do you assess if somebody is going to be a public charge in the future, right? I mean, nobody can foresee into the future. So a lot of this is going to be surrounding around the gray areas. So just a big recap. One of the things that they're focusing on is, have you ever used public benefits in the past? And which ones are okay, which ones are not okay, and which ones could be a problem? That is the analysis that is completely changed. Some, under the Biden administration and in the past, they very, very narrowly focus on these are the ones that are not okay. But everything else, don't ask, don't tell, go based on everything else that the immigration has. You have a joint sponsor, you have current W-2 income's good enough, that's approvable. Basically, in the past, the government didn't want to be in a position to reject somebody's green card to be able to stay in the United States just because they're too poor. That seems like it is not politically correct. But in this administration, they want to do that. They want to heighten that up, potentially tenfold, hundredfold. They think there's too many people who are a public debt to society and they have let in, and so they want to stop that in the future. So that's what we're going to be talking about and going in depth. But I see there's already a lot of questions, so
So feel free to ask any questions you have, and we will get to them. I see a couple people send questions, but then retracted them. So if you want us to get into the questions, feel free to just put them in the chat. But for now, let's continue with the
Okay. So let's talk about what it was before, just a little bit. What it was before was, did you use federal government cash assisted programs for a long period of time? So that's three factors, right? Did you use government subsidies, federal government, not state, federal government, and did you use it for a long period of time? If so, well, you used it before for a long period, chances you will continue to do it. And so maybe you have a joint sponsor, but that's not good enough. We still have to deny your green card application, whether you're applying for a green card overseas or you're applying in the US. That was the test. Now they've expanded that. And in the 45 application, they're going to be asking a lot more. Have you ever used any sort of benefits? And they leave that extremely broad. And then they're going to ask questions. When did you get it? How long did you get it? What kind of program was it? And how did you apply? How much did you get? Doesn't mean you're going to get denied just because you use something, but now they're asking a lot more information. And so now every immigration practitioner, every immigration application, when you're doing adjustment of status, if you've ever used any sort of programs, whether it's state, local, federal, how long did you use it for? How much did you get? You have to disclose all of that. And then now you need to make the argument that was a one-time thing. That was for my children, not for me. That was for this particular program that I didn't even try to apply. It was just automatically given to me. We're talking about Pell Grants. We're talking about going to college. We're talking about school lunches. We're talking about U.S. citizen children who have their medical care costs waived by hospitals. It was a service. It was for free. It was reduced. Therefore, it was a benefit. You're an immigrant. You need to disclose it. And that's what we're going to see in the next 10 years fight out. Is this program receiving this much in this circumstance? They received it 5 years ago at a one-time thing, and then now they have this salary. Why did you still deny them their green card? Right? And so there's going to be a lot of litigation around it, but that's the public charge issue. We'll take some questions, and then we'll talk more.
Is a one-time DUI a ground for automatic denial? I have an approved VAWA waiting on my interview.
Is a DUI
Automatically?
Not necessarily. We usually do the analysis based on when the conviction was issued, so it depends on the year. So there are a lot of different factors that would play part when it comes to a denial based on a criminal conviction. So it requires analysis and someone that's what do you call this? That's familiar with the laws of like different type of criminal convictions.
So let me talk a little bit more about that, right? It depends on what state you're in, because getting a DUI in New Jersey, in California, in Texas, all different. How severe was that DUI? Was that DUI conviction, or did it get reduced? Could it be reduced? What were the facts surrounding it? All of that an immigration officer will take into consideration, right? Because somebody could get a conviction a long time ago in one place and they move to a different state and then you apply. But the federal law is still the same. Mm-hmm. So to an immigration officer reviewing any sort of convictions, whether it's DUI, theft, anything, even if the court dismissed the case, the immigration officer still can take a look at that application, look at the arrest record, and still make a determination. No, I think you actually did it, and I think it's much more terrible. I think that's a crime involving moral turpitude. I think your case should be denied. That's an inadmissibility. So that's the way it's framed out. So what should you do? Well, AI is extremely powerful these days. In the past, you would have to hire a criminal attorney in the state that conviction happened. You have to have that attorney read through everything and make an argument that that is not a crime involving moral turpitude, and you have to have an immigration attorney match it with immigration law, and then you have a better, maybe your case could get approved, right? That is how things used to be done. People have to spend a lot of money. It sucked. Now with AI, take that transcript and ask, based on this, does it have any exceptions under inadmissibility law? You don't talk about your name, right? Just kind of plug that in, right? The conviction, the result, and then you will have a much better answer. But just because AI says it doesn't mean it's accurate, right? Double check with a couple AIs, and then you would want to, wherever you're interviewing, let's say you're interviewing California and Los Angeles, then what we do is we prepare it we would be consulting an immigration attorney that goes to a lot of these interviews and say, hey, look, this is the law, this is the facts, this is the argument, but what do you think Jose, immigration officer, would say to this? What do you think, Carl would say to this? Because they know all the different officers, they know what the policies are, and what are they leaning? What do they want to see? Oh, they want to see more rehab stuff. Okay, then you prepare a little bit more of that, right? So that's the big picture on how immigration law is practiced. Is a DUI, is this conviction going to deny your case or not? Well, that's how you kind of help yourself without having to spend money, right?
I'm hearing it depends.
Yes, but I hate just saying that, because anybody can say that, right? So I want to show you exactly what it depends on, how you can find out more clarity, and how you can boost your chance of success, et cetera, et cetera, et cetera.
I have a U visa, did my change of status to get a green card this year. Can I get picked up and deported? Do I have protection?
We don't do U visa cases. To my understanding, U visa has the highest protection than anything else, and including waiving a lot of various criminal offenses and serious offenses. So more likely than not, you are shielded. But ICE is extremely powerful, right? So they might not recognize it. But in this case, you're a U visa holder. You are already working with law enforcement. So I haven't seen ICE go after U visa people. But, again, that's not our area of expertise.
What are your thoughts on flying domestic with a pending I-751 and an expired green card?
Oh, with the extension.
Yeah,
Okay.
already have the extension, no criminal record, have real ID. Some people say yes, some people say no.
Yeah.
What's your take?
I'm assuming you are concerned because of the news you saw where somebody was flying in a domestic airport and the TSA alerted ICE and ICE picked up certain people because they have a pending 485 application. Their I-94 is expired. In the past, that has never happened before, but it's starting to happen. Somebody came in as a tourist, they overstayed their visa, they got married to a U.S. citizen, they filed, they have a pending 45. In the past, nobody would arrest them. Nobody would detain them. That situation is very different than your situation. You have a green card. It expired, but if you look into it, in the past, green cards never expire. Okay, so just so you know, in the past, green cards never expire. Your conditional green card expired, but your lawful permanent resident status might not have expired. And since you already filed 751, it automatically extends for 4 years. So for all intents and purposes, to ICE and to anybody else, you have a green card, your lawful permanent resident status, until USCIS denies you, until you can't get a 551 stamp, until you get a deportation order, you are a lawful permanent resident. Following up on that, if ICE does pick you up, it doesn't meet their quota in a way, right? They're trying to pick up people with I-95 overstays, I-94 overstays. They're trying to pick up people with criminal records. You are a green card holder. That is a pending application. So unless you have a criminal record or a threat to public safety, then it might hit their quota, but you don't really fall in line with what they're looking for. So I don't even think TSA will alert ICE if you're on the plane. That's my opinion.
Okay, so do we have more to talk about with public charge?
Yeah, we just started. We just purely set the stage, right? Yeah? Okay, all right, we're going to get to it. So, again, this is a brand new area, right? Immigration attorneys, we didn't have to study every single type of benefit from every single county, state, and government. Before, it was very clear. Federal benefit for a long time means tested. Okay, you probably won't qualify. We don't encourage you to file, right? But now, any benefit, not just you, but your family members, all becomes under scrutiny. And so our policy at a firm is double the amount of financial ability to try to overcome a case, right? So in the past, again, you have one joint sponsor, you meet the criteria. It's a very simple math, formula. You have certain W-2 income, you have so many dependents, you meet the 125% poverty guideline, you have a certain amount of assets, it's 5 times the amount of what the poverty guideline is. It's a math game, sign off on it. You have a certain income level based on where you live and how many family members you have. You pass it, done. Now, because of the new public charge rule, we try to at least double it. just in case your income's enough, well, can you also just have a joint sponsor? If you have a joint sponsor, and you can only get one joint sponsor, can you also now prove your relationship with that joint sponsor? Have they supported you in the past and not just promising that they will support you? You know, your close relationship. So we do more to assure the government you should, for sure, you will not be a public debt to society. If you use the benefit before, we show that it was a long time ago. We show that it was a one-time thing. We show that you didn't apply for it. We show that it wasn't for you, it was for somebody else. We show that it was an investment to something else, right? You got a grant for education, but then now you achieve that education and now your income is that much higher, right? We have to spend a lot more time preparing that. And again, it's for the officer to look at and say, oh yeah, this person will likely be able to continue to make money. It's they're healthy enough, because again, public charge also looks into your health. If you are unhealthy, if you use a lot of Medicare, Medicaid, if you use a lot of these type of things, you're unable to work, you're not able to hold down a job, you have bad reviews, well, the government might think, well, then there's a high chance you might become homeless, and now the government has to support you. We don't want you, right? So it's really important for anybody who's applying for these adjustment of status applications. Improve your resume. That's very much a part of it. Your credentials, your resume, get really strong letter of recommendations from people saying, yes, we're willing to offer this person a job. Show strong tax returns in the past, even if it's not a super high amount, but consistent, it's pretty important. Various assets that you've accumulated, skill sets that you've accumulated. And then if you did use any benefits, we need to document all of them. Every single one. Document it, and then be able to prove that it was, again, not indicative that the future will be like the past. Anyways, I mean, what do you think?
Special circumstance. Yeah, I think it's important to highlight the special circumstances. What, like the situation when the person applies for, like if you were 18, 19, like a teen parent, and then you apply for government benefits, you just graduated high school, you don't have a career, you didn't go to school yet, and then, you have children, you can't go to school because you have to take care of your children. And then I think what's important to highlight is that I learned that for these government benefit programs, if you have U.S. citizen children and you are undocumented, when you apply for the benefit, the social workers have to assess your eligibility to either deny you or approve you for the benefit. So in other words, in order for the children to get the benefit, the parent has to undergo eligibility assessment. If they find a loophole where the parent can get it, then they have to grant it to the whole family. So in other words, for people that have applied for like food stamps or Medicaid or whatever for their children, it's not so much that they wanted to get the benefit, it's part of how the system is set.
Right.
And that's what I learned.
Yeah.
One of our clients just immigrated. She's a U.S. citizen. She brought her family from Mexico. And when she went to apply for health insurance because her daughter is sick, they are saying in order for us to deny her benefit or to exclude her, you need to prove that she's ineligible through whatever means. So she had to provide a copy of the affidavit of support showing that she has a sponsored and that this could potentially affect the sponsor. So it's like these programs, the eligibility for the program is based off of like a household, not just one person. So even if the parents did not want to receive the benefit, they have to prove why they cannot or why they should not receive the benefit.
Right.
So it's tricky, right? Like now a parent that has a 21-year-old child that's applying for adjustment, but the children receive Medicaid and somehow the parent has emergency Medi-Cal.
Right.
It's against, they didn't want to apply for it, but it's part of the program and they receive it anyway.
Yeah.
So I think those are all like things that we have to get ready to explain and just learn a lot about all these programs. The government has endless amount of programs, especially when it comes to the Medicaid.
Right.
There's like different tiers, different type of benefits. Yeah. Different levels. So it's a lot.
And again, explaining where time and space was really important. Back then, the children were young. And the parents were undocumented, or the parents were just starting off their career. And so they had to get vouchers for Section 8 housing. They were living in this situation. But now, fast forward 15 years, the children graduated college. They are, straight A students. They're very capable, and the children can sponsor their parents, and the children can be able to have great jobs. They're U.S. citizen. Now, the parents also, after 15 years, they have also advanced in their careers. And so now you're not trying to survive with a family of 4 or 5. Now it's just one individual trying to get a green card with everything else that happened. Yes, they did use the Section 8 voucher a long time ago, but that's not indicative of what's going to happen 5 years from now, 10 years from now, right?
Mm-hmm.
So there's a lot of these type of explanations that's going to have to play out, and officers have the discretion to look at the whole picture and to make a determination. It's not just, they're not limited by the old form where you can only consider these means tested programs. Now they can look at every single program that they benefited from, right? So it's a lot more explanation. But the worst thing is if you don't disclose it and USCIS finds out about it, now that's fraud and misrepresentation, right? You used the program, you didn't tell me, you knew you were going to get denied on it, and so, or you can't find it, right? It's better to say there's all these things I might have used more, I really don't know, I can't find it, I don't know what I qualified for in the past, it was so long ago, but this is my entire situation. So just being truthful and honest, but not subject to fraud and misrepresentation. And that's the next thing I want to talk about, because there are a lot of interviews where we see the officer, hey, I discovered something that you didn't mention, and now that's fraud and misrepresentation, and you have to apply for a 6-1 waiver. So we've seen it with them digging back into their past. Oh, when you applied for a student visa a long time ago, you said this, but that was not true. And so now that's fraud. And you got your visa, you came into the US, and now you got married, and you got a green card, and that's a problem, right? And so there's a lot of different fraud and misrepresentation that gets issued. And when we do fraud and misrepresentation waiver cases, we prove extreme hardship on the US citizen spouse or the green card holder spouse if the foreigner was to be removed. Part of that argument is financial hardship. We have to prove, hey, look, it's double income right now, it's keeping this family afloat. But if you remove one person, if you say they committed fraud and misrepresentation and you deny them a green card, that's going to cause extreme hardship on the spouse. But now that's double-edged sword, because if public charge is an issue, if you remove one person, if one person, one income alone cannot survive the family, well, then maybe you guys can't afford to live here. And maybe I will deny you based on public charge. So this is tweaking the way we have to prepare for a waiver application, 601 applications. We don't want to lean into the finances that much. It is, and we want to focus on both pictures. It's both families together, both people able to work, and then it's going to have a big, successful family. If you remove one person, that's extreme hardship. But they could make it work. It's extremely hard going from a really high income to very low income, right? But anyways, this is all playing out. The new form is going to go live in September. It's still being updated, and so everybody needs to watch out for it. Don't use the wrong form. If you use the wrong form, it automatically gets denied. If you use the right form but you don't fill it out correctly, it will get denied. USCIS doesn't have to give you a request for evidence or a NOID anymore. It could just be straight up denied, and you have to repay all the application fees. And if you do fill it out and you have used benefits in the past, well, now you're going to have to do a much better job explaining everything. But that's the rationale, right? It was one time, it was in the past. I'm much better now. Going forward, I'm much better, and I'm double or triple the basic requirements, right? My income's enough, my assets is enough, I have a sponsor. There's no way I'm going to be a public charge. Please don't deny me.
Yeah, so feel free to add any more questions in the chat. I'm curious what you guys think of this public charge rule, both you guys and our viewers.
It makes sense from a government standpoint. You don't want poor people that come into the country that will become a burden, right? You don't want all the taxpayers to be doing charity for the rest of the world. That being said, it is very non-PC. Somebody is married to a U.S. citizen, they live here, they have kids here. It's tough, they're struggling, and they struggle at one moment in their life, one period of their life, maybe this year, maybe last year, and you deny them. That's very non-American, right? America believes in second chances. America believes that future is better than the past. America believes that that can happen. But just because you use this one benefit that maybe you didn't even apply for, and count that against you, right? And so I see it both ways. I see the benefit of USCS officers having the totalitarian uh, ability to examine all things. That seems to make sense. You use his benefit, but based on your education, based on your career, I think you're fine. I approve you. That's what a good officer would do. But we're dealing with bureaucracy. We're dealing with the government. We're dealing with government workers. And what if you get a bad apple officer that says, you know what, I just don't like this. And I just want to deny them. I have the authority, I have the discretion. It's my job. And, I see that you use the benefit 1 year. I see you use the benefit again the second year. I see you benefit the third year. I see that you have this particular income. I just don't think you're trying hard enough. And I think the government gave you more than you have poured back into the country. And so I'm just going to deny you. And in the past, that rarely happened. But now it can. Is that good? Is that bad? A lot of people are going to be stuck in the middle. And I think that's what everybody needs to know. It's not as simple as it was in the past. This public charge thing is going to dramatically change. And it's not just this administration. I think it's going into the future as well. And the immigrants are the one always paying the price, right? The U.S., if there's unemployment, if it's tough to live in the U.S., you need an scapegoat. Boom. It's always the immigrants that get blamed. It's always the immigrants that pay the price. You can imagine somebody waited for a decade to immigrate to the U.S. They saved up, they worked hard, and at this critical moment, they can't reunite with their families. Why? Or they get deported. Why? Because, well, I just don't think you make enough money. It sucks. But that's the reality.
Yeah, and I do like that, the nuance, right? Because I think it's very easy, especially for, I'm just picturing the comments we'll get of like, oh, if you don't like this, just, don't take public benefits. Like, we don't want these people. But there's a lot of people who, it's a gray area. There's, it's nuanced, right?
Area. Yeah. I was going to say that, like, the circumstances are so different for everyone. And I think, like working with a lot of immigrants for the past 14 years, I've gotten to see that when they do apply for these benefits or receive these benefits, is only when they really need it. It's not because they want to take advantage of the government, but like both spouses lost their job, or the U.S. citizen fell sick and now they can't work anymore, and they were the main breadwinner for the house. And it's not like they go and apply for these benefits to take advantage for the most part. And I'm not saying that's like everyone, but for the most part, it's when they really need it. And then even then they are like, oh, I didn't use the benefit for a long time, only while my husband got a new job, and then we completely stopped. So for the government now to say we're gonna look at how long, when, where, it's like you can't really predict when you're gonna lose your job. You can't really predict when you're gonna get sick. So hopefully we get good officers that really look at the whole picture, and not just that one time or that one instance. So it's definitely very, very different, but
one of the staff here, we spent a whole month already preparing this, and it's so awesome. And we could share it with any of the viewers who are interested in seeing it. Just leave your email or leave your contact. Just comment and DM us, then we could send it to you. I'm just putting it out there. It's a lot of work on Galen, but it's awesome because it shows what benefit. And if you get this benefit, how do you argue that you still are not a public charge? And we have benefits that it applies now and in the future. We have, we see like SNAP benefits, Medicaid, federal Pell Grants, emergency rental utility assistance, state-funded healthcare coverage for immigrants, specifically Medicaid-funded nonprofit supports, energy assistance, right? So these are some of it. It's like tier 2. It could be a problem. It will kick into effect, but how do you argue it? So we have sample arguments. We have which ones are gray area, right? Job training, workforce development program, child care subsidies, vouchers, social security, retirement, a lot of things you self-funded, you paid into it, veteran benefits, right? You served and you're entitled. So some things are more okay, but what if the officer doesn't understand it? They think benefit is a benefit, right? And so we have things that are, this is for sure a problem. You really have to do a strong argument. Here are the ones that could be a problem, but you really need to explain. Here's the ones that are the gray area, and here are the ones that most likely is fine, but to a, not so intelligent officer, not trained, they might not know. So you have to do your job to explain it to them. So we have all of these programs, and we have all of the arguments, and we are preparing it because we need to study it, right? If we are helping immigrants apply for green cards and they're showing up and they say, I have this, is this a problem? Well, I don't want to say it depends, it depends on what? It depends on the officer's feeling that day, what they have for breakfast. We want to be able to have a much more sophisticated answer. Well, let's talk about it more. Okay, this program, how did you get it? What's the application? How much did you get? When did you get it? What is your income now? Do you have a joint sponsor? Do you have everything else, right? And so we created this. It's obviously too much for me to read every single one right
I'm
here.
sure we'll display. Check back when we post the video. We'll display parts of it as well.
And then and if you're interested, right, we could send that out. But that's the work that we're doing, right? Or else if we don't do this, then what's the point of a law firm, right? You could just fill out an application and file it and just say, it could work, it could not work. It's like buying a lottery ticket. That's not why we went to law school. That's not why we are in this profession, right? We want to help each individual applicant make it the highest chance of success as possible and zealously advocate for the client, right? That's the oath we swore to the state bar. But anyways, that's the public charge thing.
I know we have. Oh yeah,
there's so much more that we have to go through.
Yeah, we have a lot of stuff to cover today.
Yeah. Oh shoot, we don't have that much time. Let's go over your case first before I talk about
the story.
Yeah.
Okay. So this was a DACA applicant that we applied for advance parole last year. So he went back to Mexico, came back in March 2025, and then waited a few months before applying for adjustment of status and just got his interview this week. So first off, the DACA advance parole back then got approved within like a month. So it was very fast. He was able to go get his lawful admission entry and married a U.S. citizen and then qualify for the adjustment. So during the interview yesterday, the challenge was whether they have a bona fide marriage or not. Whether like they are together for the right reasons instead of just for a green card, even though they have a child together that's only 3 months old. So the argument of the officer was, why don't you have a joint bank account to commingle your financial assets? You should have one because now you're married, especially you have a child. There are a lot of expenses with the child. So that was the main challenge and the point to highlight. We've never experienced this before. Done many marriage-based adjustment cases, even without children.
And this interview lasted 2 hours. 2.5 hours, challenging whether the marriage is real, even though they have a 3-month-old. And I mean, that's the entire child's nap time. I mean, the child is only awake for that long, and then the child needs to go back to sleep. It's crying. There's all sorts of issues. Our attorney was there and had to call a supervisor.
Correct.
It was really intense.
Yeah. So there was a point where the officer was just going around in circles trying to find out whether they were in a bona fide relationship or not. So, our attorney had to stop the interview politely and then just say, is there any way that you can call a supervisor? Then the officer retaliated, saying, why would you need a supervisor? I'm already telling you that I don't believe this is a real marriage. And well, why don't you believe it? Though it's just, you have to kind of like give us some more substance to your decision. So then they called in the supervisor. Even the supervisor was really shocked at what was happening when she was brought into the room. She said, what is going on here? Don't you guys have a child already? And then the client said, yeah, we have a 3-month-old baby. We've been together for 10 years. We just got married last year. And, they were planning on doing like a big celebration for their wedding. And that's kind of what took a little bit longer for them to get married. So once they explained the same thing that they explained to the first officer, the supervisor said, I really, I'm very sorry that you went through this. I really, hate when you guys have a bad experience when you come to our office. I'm going to approve it on the spot. So cases are not approved on the spot nowadays.
Yeah.
But because of that whole ordeal, the supervisor said, I'm going to make it up to you. I'm approving it on the spot.
Right.
So they got an approval on the spot for this marriage-based case. But it was just really weird.
Yeah.
How do you, so are they trying to say that you're going to bind yourself through a joint bank account, but you're not binding yourself for life with a child?
Yeah.
Like,
it's crazy. Like, we had another case where a woman was pregnant like 8 months, and the officer said, well, that doesn't prove your marriage is real. And the argument the officer said was, well, the child's not born yet. I don't know who the real dad is. You could just be pregnant. And then it's like, well, all the appointments, everything else, really? All the family, like, shared it with all the family members, and no, it's just faking it, which the officer, it happens, that's not indicative. So that was the farthest extent that I've ever experienced. But this one, having actually already born a 3-month-old, and the evidence that the officer wants, on top of that is a joint bank account.
Yeah.
And I always tell my clients, like, if a fraud criminal ring can fake it, it's useless. And a joint bank account is one of the easiest things to fake.
right.
Like two people go and and you can even do it online banking. You don't even have to show up, and you can get a joint bank. Like, what does that prove? You bought some eggs from Aldi, and you bought some, spinach from Sprouts, and therefore you have transactions, and therefore it's real. Like, but baby doesn't count.
You'd have to be a really dedicated scammer. to do that.
So yeah, it's crazy. Now, what I've also been told by consulate and USCIS officers is that the threshold is about 80%. Meaning, if your exact same situation and there's 10 different officers reviewing it, if 8 officers look at the exact same situations and say, oh, yeah, I would approve it, then you passed. And that's why I think in this situation, if you ask 10 officers, I think 8 or 9 officers would approve the case.
Right.
But that one officer looking at the situation is thinking no, then he's basically contradicting 9 other people. And that's why the supervisor was so easily able to say, no, I'm going to prove this case. Well, because this also never happens, and then we're glad we have a good relationship with the supervisor. We go there very often. That's why it's so important and we didn't even think this was a difficult case. I mean,
no, we this was the last one that we expected to have a problem at the interview.
Yeah.
So besides the birth certificate and the individual bank accounts with the same address, the IDs with the same address, they had a ton of other evidence, like the lease agreement. They had credit cards together. They had like just a lot of other proof, like history of like pictures from like 10 years ago.
Right.
They were kids when they started dating. Now 10 years later they got married. So it wasn't even like it was just one piece of paper or just a birth certificate. There was tons of other evidence that proved that they were in a legitimate relationship.
Right.
I don't know if it was the DACA, lawful admission, the advanced parole admission.
Well, we thought that was the biggest concerning thing because the Supreme Court new ruling, right? In USCIS's new ruling, if you leave on the BIA decision, if you leave on DACA and you come back in, that is considered a departure and reentry that kicks off your 10-year bar, and now you are forced to file a waiver now. That is the biggest change, and we're really concerned the officers don't understand that they already left and they came back in. It's not retroactive. You can't punish the past. We were concerned about that, and that's why attorney going was really, really important. But we never suspected them challenging the bona fide marriage aspect.
Right.
They're good officers.
Pretty interesting.
They're challenging officers. It doesn't seem to make sense, but I'm glad the supervisor was able to step in, and the system still worked.
Yeah.
And can anyone call the supervisor in, like, even without a lawyer present, or what's the procedure there? Because it seemed like that was kind of the key in that situation.
We tell the clients, yes, you can call the supervisor if you go by yourself. It obviously makes a lot more sense for the lawyer to call the supervisor, but anybody who's applying, especially the U.S. citizen, you paid for the system. You're a taxpayer. You have rights. And that is part of it. In the U.S., you have that. If you're doing overseas, the U.S. citizen is not going overseas for the interview, so you have very, very little rights in petitioning somebody overseas. And there's a Supreme Court ruling about that as well. It's not a constitutional right, but at least within the confines of USCIS, adjustment of status, you're petitioning somebody else, you can do that. And I think the basis is, if the officer is a little bit rude, you don't like the way they smell, you don't like the way they're insinuating certain things, you don't like how slow they talk, that's not a reason to call the supervisor.
Right.
The threshold really is, take a step back, your situation, your concerns, 10 officers, will 8 or 9 of them clearly approve your case?
Mm-hmm.
And you are a reasonable, rational person as well, right? So you assess the situation. And if this particular officer really took it too far, that's when you really call the supervisor. And we've done this on occasion. We don't always call the supervisor. It's actually quite rare.
Yeah, it's only when there is something difficult, like a situation where, we're trying to explain to the officer, giving them the opportunity to review everything, and the officer has just said on something that's like, nope, it's not a real marriage. No matter how many documents you show me, it's not a real marriage. It's like, okay, now we need a second opinion, kind of.
Right. Because if the officer says, you know what, you could go home, I'll send you a notice, there's not much you can do, right? Because the officer, that's what the officer can do. But in this instance, the officer says, I just don't believe you. So the officer's going to deny the case already. It's not even like, I'm going to request more evidence. I'm going to deny the case because you don't have a bank account. And so like at this point, hey, I think your logic is off. You really need to take some LSAT courses. Let's call supervisor in, right?
Okay, so I want to take some more questions.
Yeah.
Is financial aid considered a public charge?
So that's crazy. From our research, Pell Grant, financial aid, because it comes from the government, right? So if you got financial aid from a private university, private school, you have some love offerings where people are selling cupcakes for you. So again, prior to the new form, prior to the new law, before it's federal government giving you cash assistance for a long period. That was the factor test. Now, if it still meets that, that's obviously concerning. And so school aid, if it comes from the federal government, it's for a long period because it's several years, and it is a cash assistance, well, that kind of qualifies. But that is, before it didn't count, but now it's concerning. But the way at least our firm is going to do it, and unless we change it up later on, we're going to encapsulate that as that is not proof that you will be a public charge. That is an investment by the government and you, with your tuition, jointly investing in your future, and that you will be able to succeed. Very different, because the whole public charge is that you will be a debt to society. Well, now spin that argument around. Because of this investment, you will now succeed, and you will repay the government in your taxes.
I have a green card expiring in 2030. I've only visited the U.S. once for 2 weeks last year. I left because I had to support my wife and newborn. Thus, I am 1.5 years out of the U.S. Am I out of status now?
So, your green card is still yours. You're still a lawful permanent resident. You still have all the responsibilities of a lawful permanent resident. You're still required to pay taxes worldwide. So you have all the responsibility of a green card holder. To the U.S. government, on paper, you are still a lawful permanent resident as well. However, will the consulate be willing to issue you an SB1 returning visa to come back in the U.S. as a lawful permanent resident? The answer is probably no. There's probably less than 1% chance that they're willing to do that. Will a customs officer, in reviewing your entry, allow you back in, or will they determine, well, you might have abandoned your green card, and therefore I'm going to confiscate it, give you an NTA, and now you have to go speak to an immigration judge? We've seen some custom officers do that with somebody who just left the U.S. for 6 months, some even less. You frequently travel to the U.S. outside the U.S. too much. Based on your answers, I think you've abandoned it. So, so you have to explain. So, if your question is, am I a lawful permanent resident? Yes. The second question is, well, what benefit does that give me? Will the consulate be able to give me a returning visa? The answer is probably no. if your question is, will customs let me in as a green card holder and then, easily, the answer is probably also no. You still need to prepare a lot of documents to convince the customs officer that you did not abandon the U.S. as your residence and that you are returning. And then if you could prove that and they let you in, and then you establish ties and then you apply for reentry permit, you might have a chance of being able to renew your new 10-year green card. So we do a lot of these type of cases, probably over 1,000 a year. And feel free to check it out on our channel. We have a lot of in-depth videos on different circumstances. Some people left for 1 month, not 1 month. Some people leave for a couple years. Some people leave for like almost a whole decade. What are the arguments we use? These are all real life cases. I don't sit around and just like make up random hypotheticals, right? These are all real life cases that we do. Some of them we've logged. Some of them we've recently done. So take a look at that.
Okay, so feel free to keep adding more questions. We'll get to them next. I believe we have an Amy success story. Is that right?
Yeah. I'm just gonna read it. It's pretty interesting, right? And I don't think Gabby even seen it yet. All right, so this is a green card holder sponsoring their spouse, okay? And it just got approved in August of 2026, right? So it just got approved this month. A green card holder, okay, so green card husband who got their green card through the investment program, he got married to the foreigner in 2024. The husband filed the I-130 in 2025, right? And then the client, the wife, entered as a tourist September 2025, right? So after I-130 was already filed, after it's on record, entered, explained it to the customs officer, the custom let them in, gave them 6 months stay, then in January of 2026 filed the adjustment of status. So that is already a very challenging, difficult situation, right? Because you came in as a tourist and then now you're filing for adjustment of status. Then in May gave birth to a US citizen child in 2026. So now this triggers two things. Right. One, it triggers the May memo. Hey, you came in as a tourist. You filed for adjustment. Did you lie to an officer? Why don't you go back to your home country? We're already 13 million backlog cases. We could deny your case based on discretion. Second thing, you came in as a tourist and you gave birth to a U.S. citizen child. That's birth tourism. The client went into for an interview, and the case was approved. The case was the I-130 was approved first, and then a month later, just this month, the 45 was approved, overcoming two essential memos. Now, obviously, everybody was sweating over this case, right? Nobody expected the May memo, but everything was already in motion. But that's not an excuse. You can't say, "Hey, we already planned this whole thing out, and you came out with this memo. We can't change our plans." You can't. That's not an excuse, right? You could still say you could go back abroad. We're very grateful that the officer did not deny the case based on discretion. They could have. The birthright citizenship was another big problem, but it's not the child petitioning the parent, it's the husband who's a green card holder petitioning the wife. But again, the husband is just a green card holder, not a U.S. citizen. So it doesn't cover unauthorized stay. It doesn't cover a lot of other things. It's because the F2A is current. Green card spouse is able to do that. And so they want to reunite as fast as possible. We started this whole motion back in 2025, 2026 now, and 2027. And now everything got approved. It's a long time. A lot of memos happen. We're uncertain, a lot of prep, and everybody was on standby. But Amy got to get approved.
Yeah. Congrats. I'm glad the bona fide marriage was not a problem, even though they had a baby. Like mine.
Yeah. So, I mean, the baby thing, we're not worried about the bona fide marriage part. They've been married for so many years, but it's the coming in as a tourist, adjusting status within a few months, giving birth to a U.S. citizen.
Yeah, that birthright.
Yeah.
Tourism out.
So,
yeah. Really frightening.
I mean, what did we do? We just worked really hard. We explained everything very clearly. Came in, didn't plan on doing adjustment, but plans changed. Filed it. Giving birth in the U.S., medical complications. But the child is not petitioning them. Prepared everything. The client was able to explain it. The client was very highly educated, very capable. But still, up in there, it's up to the officer, you know. And if you ask anybody, it depends. And so, the best thing we can do, really, on these channels, on these videos, on these lives, is to share. This is what's going on. This is the risks. This is how we did it.
Right.
This is the result. You know, and we could just do one thing at a time, right? And one case at a time. Each week we come here, we kind of share exactly what's going on, and hopefully that helps anybody who's watching. Any more questions before we head off?
Yeah. So following up on the out of the U.S. for 1.5 years, if I sign up for your legal help, how long would the process take from now until I take the flight back?
So we have a lot of different things, right? Hopefully, just doing a consultation would be sufficient. I'm going to be on 2-week vacation, so if you want to book me, it's going to be a couple of weeks from now. But there's plenty of other people at the firm who do this, you know, and you know, Gabby does a lot of these as well, right? So maybe a 250 consultation is sufficient, and you could do everything on your own. And we do a lot of these. You know, our 250 consultation is not a sales call, right? We're not trying to like, hey, you know, hire us, right? Like we do enough consultations. We're busy enough trying to provide as much information as we can, help you, you can do it. Now, if you feel like, well, I need the entry package, I just don't feel safe, I don't have enough documents, right? I want you to be on standby, or I want to hire you, and I want you to go to the airport and stand by with me. There's so many different services that we do. Again, we do thousands of these every single year. We have lots of clients who are overseas for all sorts of reasons. So it really depends on your situation, right? But hopefully that consultation by itself is sufficient. And just check out our new channels, right? Just check out our videos, because we literally talk about everything we do and how we do it and different clients, right? And so once, maybe even that is sufficient, right?
I-130 interview is scheduled on September 30th. That's still happening right now, right?
If it's overseas, it might be canceled. If it's in the US, it's still on.
Regarding the visa interview pause, do you think they'll continue processing visa interviews by September 18th? And what will happen to the applicants that already had an interview?
Well, that's easy, right? Yeah, you can answer.
Oh. So after September 18 is the new public charge. So the cases that are going to be assessed after anywhere outside the U.S., USCIS, immigration court, anywhere, are going to be subject to the new public charge rule, right? So it's still ongoing, but now subject to that public charge rule. So people that already had their interviews, if the cases are already adjudicated, then they either get a denial or an approval, and then they can just travel with their visa or use their green card to travel outside the U.S.
If you're scheduled but you didn't go to it, they'll reschedule you, and they'll get priority compared to everybody else. It's kind of like first come first serve situation.
Okay, and that is our time for today. Thank you, everyone.
Thank you, everyone.
Thank you.
We won't be here next week, but we'll see you in about 2 weeks. Okay.
Follow up on the September 30th. Their interview is in Pakistan on September 30th.
I suspect it will be postponed.
Got it.
I guess.
Okay, thank you, everyone. We will see you all in 2 weeks.